I will be requesting Mr. Sandeep, my colleague, which I know him from last 10 to 12 years. He will be throwing some light on code on social security 2020. First, I would like to introduce Mr. Sandeep Hooda, who is a senior human resources professional. He is a graduate in law with specialization in labor laws and postgraduate in HRM. Mr. Sandeep has a career track record of 24 years in human resources and industrial relations of good Indian corporate as well as MNCs such as Escorts Class, Honda Motors in India, Skoda Auto Volkswagen India, Class in India, and Suzuki Motor in India. His main expertise lies in change management, organization planning, OD intervention, employee development through strategic initiatives, employee engagement, labor, employment and corporate laws, legal compliances, and industrial relations. Throughout his career, he has successfully managed talent selection practices, process improvements, and has efficiently managed the teams to make a significant contribution to the organization. He was also a member of Class Global HR team comprising of business units of Germany, USA, China, Russia, Hungary, India, and business unit sales and service. So now I will request Mr. Hooda to come and throw some light and discuss the new code on social security 2020. Thank you, all of you. Have a very good day. It was very nice being a part of this webinar. Thank you.
Thank you, Tufanji, for such a nice introduction. I will request Tufanji separately to introduce same way to my wife also. Okay. Good evening, ladies and gentlemen. So I'll be taking up, I'm taking up the code on social security 2020. What is this code on 2020? If you know, there were a lot many legislations, lot many acts which were dealing in social security. Now all these acts are subsumed together, and these acts were around these acts. There are 9 acts which are subsumed together, and are now they are called the Code on Social Security 2020. That so subsumed are the Employee Compensation Act 1923, Employee State Insurance Act, the Employee Provident Fund and Miscellaneous Provision Act, Employment Exchange, Maternity Benefit, Payment of Gratuity, Senior Workers, the Building and the Other Construction Worker Welfare Cess Act, Unorganized Workers Social Security Act 2008. In if you'll see the Code of Social Security, there are 14 chapters and 7 schedules. So going further, so I'll be discussing with you all these 14 chapters, but not all the 14 chapters. Some chapters would not be there where there are no changes. So we'll be discussing only the chapters wherein there is a change in the code. So we start with the code with chapter 1, which talks about the applicability of the act. So as far as applicability of the act is concerned, there is no change as far as number of employees are concerned. So it, in case of Provident Fund, Employee State, Maternity and Gratuity. But yes, in case of Employee State Insurance Act, if you see, there is one change wherein it says that establishment working in hazardous sector would be mandatorily be linked to ESIC, even if there is only one worker working in it. So this is a major change. Even if the one worker, एक आदमी एक worker भी अगर काम कर रहा है, तो उसमें भी आपको ESIC में आपकी unit को आपको you'll have to consider it, you'll have to register it under the Employee State Insurance Act. Going ahead, chapter 1 deals with the preliminary applicability and definitions. So you'll find a lot of definitions which are changed in the act. So I'll be discussing all these definitions. Some of the definitions are already discussed by Mr. Saroha and taken up by Mr. Tufan also. Like the definition of wages, again there is a change in the definition of wages. But definition of wages, if you see, it is same across all the codes. be it industry relation code, be it code on wages, be it code on social security, be it code on occupational health and safety. So in all the four codes, definition is same. Maybe this is already discussed, so I'll not talk about this definition again, but here I would like to emphasize that what is the impact of this definition on ESI PF. So it will have impact on ESI, impact on PF, impact on bonus act, impact on overtime calculation, and impact on gratuity. Because now wages is not only basic DA and retaining allowance. So whatever is paid specifically from A to I, if that is added and if the total remuneration is more than 50%, so that amount is added to the wages. So it will have impact on EPF, ESI, bonus, OT, and gratuity. In bonus, it may have some effect wherein the limit is 7,000 or minimum wages for the applicability of bonus. Maybe some of the employees, they will be out of the bonus act. And on EPF, ESI, definitely you'll have to shed more money, because it is not only basic DA and retaining allowance, it is other components also which are given over here in the definition. If these components exceeds one half of the amount, then whatever the amount it is exceeding, that will be added in the wages. And same is in the case of overtime calculation. So that will also be higher. Then we go on to the next definition of gig workers. This new category of workers has been included in this code. Now we are saying India is moving towards gig economy. What is gig economy? If you see now, the food is available. People, they are there to deliver food at home. Zomato, through Swiggy. So there are some workers, they are working and they are delivering those items at your home. You can order from any of the restaurants, and Swiggy and Zomato, they take it from there and deliver it to you. All these workers, Amazon boys, workers working with Amazon, delivery boys, Swiggy, Ola, all these workers come in the category of gig workers. So basically these workers, they are outside of the traditional employer and employee relationship. That is the catch, because they don't have employer-employee relationship. So they don't have any relationship. So that's why they were not earlier covered by the act. So now in the code, specifically these kind of workers being taken care by Social Security. And like there are a lot of freelance workers, they are also being taken care by the Social Security code. Apart from that, gig workers, similar kind of workers are platform workers. There is a very minimum difference in between gig workers and platform workers. So platform worker means a person engaged in or undertaking platform work, means a form of employment in which organization or individual use an online platform. This is what is happening. And in COVID times, it has increased manifold. So you can see people who are working in Urban Clap, Amazon delivery boys, all these guys, they will come under the category of platform workers. Then the third category is unorganized workers. These include home-based workers, self-employed workers. Home-based, like in BD manufacturing, the people, they work at home and they make BDs at home. So they come under the category of home-based workers. So there is, as far as I told you, that there is no major difference in gig workers and platform workers. This is the first time in India that the application-based assignment performed by many workers being recognized as employee-employer relationship. So going further, the next definition is contract labor. So as far as original definition of contract labor is concerned, there is no change, it remains same. But now it includes interstate migrant workmen also, and it does not include an employee who is regularly employed by the contractor for any activity of his establishment, and his employment is gone by mutual accepted standards of the condition of employment, including engagement on permanent basis. and gets periodical increments in the pay, like social security coverage and other welfare benefits accordance with the law for the time being in force in such employment. So those employees will not be covered under contract. They will not be called as contractor labor. So they will be employee of the contractor. So second change is now the contractor includes subcontractor as well. Earlier in organization, what was happening, the contract was given to one contractor and he was giving it to subcontractor, and some contractor was giving it to another contractor. So there were so many contractors, but only one contractor was recognized. But now even the subcontractor is also there in the code. Next definition talks about employee. What does employee mean? Employee in the code on social security means everybody who is working in the company, he be doing semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, technical, clerical, or any kind of work, but other than apprentice, engaged under Apprenticeship Act 1961. All the employees who are working inside the company directly or indirectly will come under the definition of employee. Provided that for the purpose of PF and ESI, specifically here, employee shall mean such employee drawing wages less than or equal to the wage ceiling notified by the central government. So current ceiling for ESI is 21,000 and for PF it is 15,000. So this is very important. So the definition, it says for the purpose of PF ESI, it shall mean such employee drawing wages less than the or equal to the wages ceiling notified by the central government. Further, it says the purpose of, for the purpose of counting of employees for the coverage of an establishment under Chapter 3 PF and under Chapter 4 of ESI, as the case may be, the employees whose wages are more than the wage ceiling so notified by the central government shall also be taken in the account. What does this mean? As I told you, the wage ceiling for ESI is 21,000 and PF is 15,000. Suppose we take example of PF, and suppose there are 3 employees who are getting less than 15,000 and there are 20 employees who are getting more than 15,000. So will that organization will be covered under PF or not? According to this provision, it will be covered under the Provident Fund Act, because the wage ceiling which is mentioned over here will not be considered. It is total number of employees who are there. If they are more than 20, it will be covered under Provident Fund Act. We go further, that for the purpose of Chapter 7, that is employee compensation, the term employee shall mean only such persons as specified in the second schedule, and such other persons or class of persons as the central government, as the case may be, the state government may add to the said schedule by notification for the purpose of the government. So this schedule was earlier also there in the Employee Compensation Act. So now in Chapter 7 of employee compensation, again the schedule is there, but with few changes. So now there are more employees who are covered under the chapter of social security, or code on the social security. It's a big schedule, so we are not reproducing it over here. So you can take a reference of the schedule. In the 7th chapter of the code, employee compensation, in the 2nd schedule of the code, employees employed as sales promotion employees also now covered under employee compensation, right? And secondly, shop and establishments are not subsumed in any of the act, because shop and establishment is a state subject. Every state government is having shop and establishment act. So these shop and establishment act, in my opinion, will continue to be retained as it is a state act, and in future I think there is no plan also to subsume it in any of the codes, because it is a state subject. Going further with the definition of employer as per the code on social security, it says employer means for a factory the occupier of the factory, not the manager of the, not the factory manager. In a factory, the occupier of the factory is the employer. Earlier it was factory manager also. in relation to mine, the owner of the mine, agent or the manager, and in any other establishment, the person who or the authority has ultimate control over the affairs of the establishment, and where the said affairs are entrusted to a manager or managing director, such manager or managing director will be the employer under the code. Next thing what they have added is contractor. So now the contractor is also employer. Earlier contractor was not employer. So contractor was were playing very safe. But now as per the code, contractor is also the employer and he will be responsible for his activities and for his people. And the next very important thing is the legal representative of a deceased employer will be also a employer. If suppose employer dies, don't worry, his legal representative will be called as a employer. And whatever, if some dues are there, so he'll be responsible to pay those dues to the government and to the employee. Next definition is the definition of aggregator. That means a digital intermediary or a marketplace for a buyer or user of services to connect with seller or the service provider like Zomato, Swiggy, Ola, Amazon. This we already discussed, like ours is now becoming a gig economy. So lot many big players are there which are there in the market, like Amazon is there, Zomato, Swiggy, all these people, they are there. As per section 114.2 stipulates that a scheme be formulated to provide the role of aggregator. So the role, because since it is new, so government will formulate a policy for the scheme wherein they will define the role of the aggregator. Up till now, they have not made a scheme. According to section 114.3, any scheme formulated may be funded wholly by center, partially by the center, or partially by the state or by the center. State and the aggregator, or wholly by the aggregator. So whatever these aggregators are, the scheme which is made, it will be funded by these people, these organizations like center. And further, section 114.4 stipulates that contribution to be paid by the aggregator should be between 1 to 2% as notified of the annual turnover of the aggregator. This is very important. If you see the annual turnover of Amazon, it would be huge. So you can see how much money will go in the fund, 1 or 2%, and it can go up to 5%, not exceeding 5%. And this fund definitely would be used for the social security of the workers working with these aggregators. And there is no reason, there is no reference of the term of the aggregator in the Industrial Relation Code, which was discussed earlier. Next definition is building or other construction work. Basically, building or other construction work does not include building and other construction work employing less than 10 workers. If you are employing less than 10 workers, then it will not come under the definition of building or other construction work. And if it is related to own residential purpose, you are making a house for yourself for residential purpose, and the total cost of such work is less than 50 lakhs, then that will also not attract this definition. It will not come under this definition. And but if it is more than that, then definitely it will come under this definition. The next definition, which is very important, is interstate migrant workers. What it is, and there is a major change in the definition, which is going to impact all the establishment and the factories. How it is going to impact? Earlier, what was happening? The definition of interstate migrant workmen, there was an act called Interstate Migrant Workmen Act. And according to that act, if you are getting people, workers from Bihar, you are required to register in Bihar, and you are bringing those workers to Haryana, then you'll have to take registration in Haryana. And the workers who are employed through this process were under the umbrella of this definition of interstate migrant workmen. But now during a pandemic, during Corona, what happened, that people, they started going, and the government was not knowing how many people they are going to their home state, because there was no data available with the government. and it became a big news, and it was a problem for the government also. So to come out of this problem, so government has come out with a solution wherein they are saying anybody who is working from any other state in your state would be called as interstate migrant workmen, and the definition covers workers drawing wages not exceeding 18,000 per month or such higher amount as may be notified by the central government. Suppose somebody is working in Haryana from Bihar from last 10 years, so that person will come under the definition of interstate migrant workmen. Some workmen working from Noida in Delhi, or from Noida in Haryana in Gurgaon will come under the definition of interstate migrant workmen. Then for the registration and all, it will all happen electronically. And there is again change in the definition of you'll be very relieved to see now inspectors are called inspectors cum facilitators. So when inspectors will come to you, they are not only coming for inspection, they are coming to facilitate you. So this is what the definition says. So inspector work is not only to inspect and find out the problems, their job is to facilitate the implementation of the law. So this is again a major change in the thinking, and let us see how much it is translated actually. Chapter 3 on the Code on Social Security deals with Employee Provident Fund. Again, there are major changes in Employee Provident Fund. One change is there is an option to join EPFO if you're having less than 20 workers. But yes, this option was available earlier also, but was not well known. It was not advertised. And the second thing is scheme would be formulated for bringing workers coming under the category of self-employed or falling under any other category under the ages of EPFO. Now you'll see government is trying to give social security benefit to all the workmen who are working anywhere, be they are self-employed also. This is a really very good thinking of the government. And earlier it was available for organized sector. Now it is available for unorganized sector, gig workers, platform workers, and for self-employed employees also. There is a major change in the contribution amount. As per the new code, it says the contribution would be reduced from 12% to 10%. But here I would like to read the complete para for you, because this is very important to understand, because it will have a lot of impact on everyone, be it employee, be it employer. Section 16 states that the contribution paid by the employer to the fund shall be 10% of the wages for the time being payable to each of the employees, and the employee's contribution shall be equal to the contribution payable by the employer in respect of him, and may, if any employee so desire, this is very important, if any employee so desire, be an amount exceeding 10% of the wages, subject to the condition that the employer shall not be under any obligation to pay any contribution over and above his contribution payable under the code. What does it mean? First, it is clear that the contribution is going down from 12% to 10%. But if the employee desire and employer also agrees, then it can remain 12% also. And the similar situation you must have seen in the COVID. In COVID, there was a change. There was a circular from Employee Provident Fund office wherein the contribution was reduced. But lot many employers, they continued paying 12% and they did not reduce. Why? What is the reason? Why when they were having option of saving money, why it was not reduced? There was a reason that now in most of the companies, salaries are paid based on cost to companies, CTC. It is fixed. If you reduce 2%, then you will have to pay it somewhere else. Instead of paying somewhere else, now the employer decided, let us not change it, and paying more amount in social security in provident fund, it is always better because you earn more interest rates, 1 or 2% more than the market. So in my opinion, it will not have any impact at all, although it depends on the employer. So it's only my opinion. So maybe if there is no clarity on, if there is any clarity given by the government, then it will get clarified, or by Provident Fund Department. Last time they had FAQs, maybe this time also they'll have some FAQs wherein we'll get more clarity on this. Or in I have seen there are some conflicting provisions also. In one act it says something else, in another act, another code, sorry, it says something else. So maybe with the time, with the judicial, this will be tested by judicial process, and finally if there is some ambiguity, so it will get clarified in the times to come. There is no other way out. So that is the only way out, or the government will change the code according to, if they feel that if something is wrong is mentioned. We go to chapter 3 of Employee Provident Fund. It talks about the code empowers the central government by order to defer or reduce employer contribution and employee contribution, or both, payable for a period up to 3 months at the time in the event of pandemic, endemic, and national disaster. Again, this is government is motivated by whatever happened during the COVID times. During next point is, during insolvency proceedings, any amount due to EPFO by an employer, it shall be treated as a charge on the assets of the establishment to which it relates, and shall be paid to priority in accordance with the provisions of the insolvency. Sorry, just a minute. During insolvency proceedings, any amount or EPFO by an employer, it shall be treated as charge on the assets of the establishment to which it relates, and shall be paid in priority in accordance with the provisions of the Insolvency and Bankruptcy Code 2016. Priority to payment of contribution would be over debts. Then next is pre-deposit for appeal against EPF assessment. The code provides for appeal against an order passed by any authority in regard to determination and assessment of the dues and levy or damages relating to employee provident fund by an employer only after depositing the social security organization concerned. That is, in case of appeals, 25% amount you'll have to deposit. This provision was there earlier also. So now the next point is penalties. So if you see the penalty amount is increased from 10,000 to 1 lakh rupees, and imprisonment of 1 to 3 years on the deduction of employee contribution from salary. And if you are not depositing, you are deducting the amount, but you are not depositing the amount. So that will attract the penalty of amount ranging from 10,000 to 1 lakh rupees. And subsequently, if you are doing it, then it will go from 2 to 5 years, imprisonment of 2 to 5 years, and fined up to 3 lakh rupees. Then when we go to employee state insurance cooperation, the applicability of the act remains same. There is no change. Gig workers and organized sector and plantation workers are also brought under the preview of ESI. And the next is, employer and the majority employees agree, then the voluntary registration has been allowed under this code. So it is same as under Provident Fund Code. So voluntary registration is allowed under this code also. Implemented area, the facility I say would be available in all the 740 districts. This is very important. So government is planning to give this benefit in all the districts. Benefits even when contribution are not paid. This is very important provision. If you see what was happening earlier, the employer was not paying contribution, and when employee was going to ESI, if you take the benefits were denied by ESI, saying that your contribution we have not received the contribution from your employer. But now the code says, if the contribution is not received by ESI, then also ESI will give the benefit to the employee, and then whatever benefit they have given to the employee, they will charge back from the employer along with interest and damages. So the people in the audience, the guys who are taking care of ESI, PF, wage and salary administration, please be careful to deposit all the amount on time. Otherwise, you'll have to pay huge damages, penalties, and it can go to imprisonment also. Establishment working in hazardous sector would mandatorily be linked with ESIC, even if there is only one worker working on it. This I have already discussed. Next point is the code empowers the central government to frame schemes for unorganized workers, gig workers, platform workers, and the members of their families for providing benefit relating to ESIC. And the code empowers the central government by order to defer or to reduce employee contribution or employee contribution or both payable for a period up to 3 months at the time of in the event of pandemic, endemic, or national disaster. So basically here, if you see, the government is motivated by what happened during COVID, and at that time also it was deferred. So this has now is reflected in the code as well. So if it happens in the future, so government will have a power to defer it. And the next point is related to insolvency proceedings. The amount due to SIC by an employee shall be treated as a charge on the assets of the establishment to which it relates and shall be paid on priority in accordance with the provisions of the insolvency and the bankruptcy code 2016. That means there will be a priority of payment of contribution under this code rather than other debts. So employees, because it's a social security code, so it will have priority over the other debts. Now I go to chapter 5 of the Code of Social Security. That is, chapter 5 deals with gratuity. The provisions of gratuity has been kept unaltered. There is no change from the present Gratuity Act, whether it is with respect to applicability, eligibility, except for fixed term employee. Basically, in case of a fixed term employee, gratuity will be paid to employee who has done minimum service of 1 year, and it will be paid on the pro rata basis. What does it mean? Suppose somebody has done a service for 1 year, 2 months, so he'll be paid gratuity for 1 year, 2 months on pro rata basis. Suppose somebody has done service for less than 1 year, then he will not be paid gratuity at all. And in case of working journalist, the period of 5 years is reduced to 3 years. So these are two changes. And apart from that, other employees will get gratuity as usual after completion of 5 years, that is 4 years, 240 days. It is noted that as per section 53(2) of the code, gratuity will be calculated as per new definition of wages, and therefore the cost will go up. Definitely, you'll have to budget it like that. So gratuity is going to cost you more, guys. This amount of gratuity will go up. Why it will go up? Because there is change in the definition of wage. So right now gratuity is paid on basic DA and retainership allowance, but in future the gratuity would be payable on these three components, which is wages, and on other components which were mentioned from A to I. And if it is going beyond 50%, that would be added in the wages. So definitely it will have impact on gratuity. So it's a good news to employees, but employers, they have to shed more money. Next, chapter 6 of Social Security Code deals with the maternity benefit. So basically, if you talk about maternity benefit, there was some confusion in the creche facility. As per the Maternity Benefit Act, it's earlier it was saying that wherein 50 employees are employed, the creche facility would be applicable, and in the Factories Act, it was 30 women workers. Later on, it was changed. So, and now in this code, again, there is ambiguity. If you'll see, every establishment to which this chapter applies in which 50 employees or such number of employees as may be prescribed by the central government are employed. So basically, as per maternity, as per chapter 6 of maternity benefit, crèche facility defines it that wherein 50 employees are working, crèche is to be provided. But as per occupational health and safety code, it says wherein 50 workmen are working, you'll have to provide it. So there is ambiguity. So it is not clear. So, but yeah, it is again with the time, it will be clear. And in our opinion, we should give benefit of doubt to the employees. So employees should be considered, 50 employees should be considered instead of 50 workmen in the company to provide crèche facility. But if you see the definition of crèche, what is crèche facility is now totally changed. Earlier companies were required to maintain crèche facility in the company, and it was responsibility of the company to provide crèche facility. But now there is a provision under the code that you can set up this crèche facility with the group of establishment. Some private players can establish it, hospitals can establish it, central government can establish it, state government can establish it, and it need not to be there in your establishment. So you can use the facility. So this is another change wherein you need not to maintain it, but you should have a crèche facility. You should have a tie-up with the person who is providing this facility, which is a big relief, I suppose, to all the employers, because now the number is also changed. It is now 50. It is applicable to 50 employees. So next definition is the term work of arduous nature has been explained for the first time in the code. The expression any work of arduous nature, this is again related to women employees. It says it shall mean any work which involve or requires strenuous effort or is difficult and tiring in nature. अगर इस तरह का काम है तो वो इस एक्सप्रेशन में आएगा. तो ये भी इसमें इस बार डिफाइन कर दिया गया है एक्ट के अंदर. So now I go on to next chapter, chapter 7, employee compensation. Report of fatal accident and serious bodily injuries. Nothing in this section shall apply to establishment to which chapter 4 ESIC applies. So chapter 7 deals with employee compensation. If some establishment is already covered under ESIC, then this chapter will not apply to that establishment. It clearly says that. Earlier also it was there in the act. In earlier act it was also limited to factories, but now the code specify that it applies to establishment as well as establishment. As you remember, I told you now gig workers are also under social security, platform workers, unorganized sector is also taken in the social security. So the umbrella is big. So under this umbrella, so now the establishments are also, they also come under the it applies to establishments as well. Next is code clearly specifies that the compensation is payable even when the employee is going to work or returning from home from work. This is very important. Earlier, there were a lot of decided cases. Before I tell you about this, I would like to share one thing. I have seen in all the codes, there are a lot of definition, there are a lot of changes which has happened, which were not there in the act, but they were already adopted by some of the states through their legislation, through their notification, or it was through judicial process. It was declared by Supreme Court. When once something is declared in the Supreme Court, then it becomes a law. So there were lot many cases wherein it was decided by the Supreme Court and everybody was following it, but it was not amended in the act. Now all those changes also amended in the codes, all the 4 codes. So this is one wherein it clearly says specify that compensation is payable even when an employee is going to work or returning from home. So earlier it was paid based on the decided cases, but now it is specified in the code. It is more clear to everyone, and all the employees can now, if something happens, they can take the benefit. The court specified that once an agreement has been arrived at between the employee and the employer, the payment of compensation, it will, for the payment of compensation, it will disentitle employee for instituting any civil suit for the same. Earlier, what was happening? People, they were taking compensation and then they were filing a suit. So now in the code, it clearly specify once it is settled, then you cannot file a civil suit. So that makes life very easy. Otherwise, employer keep on running from pillar to post, from one court to another court. And you know, in India, like court takes a lot of time to decide the case, even if it is of no value, or if it is wrong, it is wrong also. And then the next change in the act is the amount payable for funeral expenses has been increased from INR 5,000 to 15,000. Earlier it was 5,000, now it is 15,000. In early act, where an employer is in default in paying the compensation due within 1 month from the date it fell due, in addition to arrears, had to pay simple interest at the rate of 12% on the amount due. Now the court states that the rate of interest will be as prescribed by the central government. We continue with the chapter 7, employee compensation. The sum payable as compensation specified in section 61 has been increased and not less than rupees 5,000. Earlier it was not less than rupees 10. So from 10 it is increased to 5,000. And there is a provision in case of this provision is added in case of medical examination, in case of accident. If medical examination is required, then the medical officer, medical practitioner will have a right. So those things are mentioned over here. Next is it has been added that the contractor shall be liable to indemnify the employer with respect to compensation under this law. So the contractor cannot run away. He'll have to indemnify the employer. The next point states that the competent authority may provide an advocate from the panel of advocates maintained by the state government to the dependent of the deceased employee who is not in the position to engage an advocate to file a claim for the compensation. The next chapter is chapter 11, authorities, assessment, compliance and recovery. There is a change in case of a limitation period. Limitation period for inquiry and determination for dues in the matter of contribution of ESNI and PF. There is change. It's a big relief to all the employers and all the employees who are involved in wage and salary administration, because now it says that the inquiries limitation is of 5 years. Earlier, what was happening, whenever the inspectors they were going for the inquiry, when they were going for the inquiry, so what was happening, they were checking a lot of things. They were going in detail, and they were checking like maybe they were going for 10 years, 15 years, they were checking the accounts. But now the code restricts it up to 5 years only. Under this chapter is the outline of procedure, namely ESI, PF having web-based inspections. This Mr. Kohad already explained that now these web-based inspection, the selection of inspection would be on random basis, factories will be considered, and unique number of establishment would be given. In addition to that, the inspector is now called inspector cum facilitator in all the courts. This we already discussed. Employee may file returns electronically, issue wage slips. This is quite happening right now also, but in future, after the implementation of the code, maybe in all the returns will be filed electronically. Time limit is also prescribed for the completion of all the inquiries. The next is chapter 12, offenses and penalties. The fines have been increased by up to 10 times. So everybody will have to be very careful. The fines are very much high nowadays, as compared to previous acts, now amounting rupees 50,000 to 1 lakh rupees. Subsequent offenses, fine has been increased to INR 2 lakh. provided that where such second and subsequent offense is for failure by the employer to pay any contribution, charges, cess, maternity benefit, gratuity, compensation under this code, he is liable to pay for such second or subsequent offenses, be punishable with imprisonment for a term which may extend to 3 years, but which shall not be less than 2 years, and shall also be liable to be fined of 3 lakh rupees. So now here all the guys managing wages and salaries will have to be very careful while dealing with ESIPF and depositing ESIPF on time. Now I go to the next chapter, that is chapter 13, which deals with employment information and monitoring. The code may make it mandatory for all establishments with certain number of workers or more to compulsorily report vacancies. This was already there, but now they have introduced there'll be online portal which will be called career portal, wherein you'll have to put in all the vacancies. And in chapter 9, miscellaneous, Aadhaar card is mandatory. As you are aware, in some of the transactions earlier in Provident Fund, Aadhaar was already mandatory, but now it is mentioned in the code. And as per the section 145, it has been enacted that in case of transfer of establishment, this is very important, the employer and the person to whom the establishment is transferred shall jointly and severally be liable for payment of the cess or other amounts under the law. However, the liability of transferee will be limited to assets obtained by him in the transfer. So the person who has transferred cannot say that I have transferred, I am not, no, I am no more responsible for the dues. Right, gentlemen. So I am over. I have completed the code on social security with this. Now.